So I'll tell you something. Somebody said to me, Alina, would you rather be smart or pretty? And I said, oh, easy, pretty. I can fake being smart.
Whenever I do a video on Donald Trump missing a key legal deadline or making a massive legal blunder, I always like to share that video that I led with there because it's a perfect exemplar about what MAGA is all about. And now Donald Trump missed a key deadline to file a petition for certiorari, or an appeal, with the United States Supreme Court following the D.C. Circuit Court of Appeals decision in the Blassingame case. This was the civil lawsuit filed against Donald Trump, with other cases consolidated with it, that alleged that Donald Trump was responsible for injuries and emotional distress damages and other misconduct relating to the January 6th insurrection. But recall that the Blassingame case was the civil lawsuit, not the criminal case. And there, a 3-judge panel, including one of those judges who was appointed by Donald Trump, came together and found that Donald Trump does not have absolute presidential immunity in civil cases relating to the January 6th insurrection. They found in the Blassingame decision, the D.C. Circuit Court of Appeals held that Donald Trump's conduct was outside the outer perimeter of what would normally be entitled to presidential immunity, because the D.C. Circuit Court of Appeals ruled that Trump's conduct was not within his Article 2 powers. It related to campaigning. It related to elections. It related to things that are not within the province of what a commander-in-chief or a United States president is supposed to do, and therefore it's not entitled to any of the immunity. And the Blassingame decision, which was decided on December 1st of 2023, was a major landmark case. And what we've always been talking about here on the Midas Touch Network is, in that civil case right there, if Donald Trump is not entitled to absolute presidential immunity in a civil case for January 6th for the insurrection as determined by the D.C. Circuit Court of Appeals, then clearly he should not be entitled to absolute presidential immunity in a criminal case. Clearly, criminal conduct falls outside the outer perimeter of what would traditionally be entitled to receive absolute presidential immunity. So just so you recall, this was the decision right here, December 1, 2023. You had a 3-judge panel that made this decision in the Blassingame case. You had Judge Katsas, who was actually a Trump-appointed judge who ruled against Donald Trump here. You had Srinivasan, the chief judge of the D.C. Circuit Court of Appeals, who wrote the decision. And then you had Senior Circuit Judge Rogers also concurred. So you had all of the judges on the D.C. Circuit concurring right here. After they ruled on December 1st, Donald Trump had until February 15th if he wanted to file a petition for certiorari with the United States Supreme Court to challenge that ruling. Donald Trump blew the deadline. He missed the deadline. Whether he did that on purpose or whether it was negligent or whether it was even something worse, Trump did not file the petition for certiorari. So for now, all of these civil lawsuits against Donald Trump relating to the January 6th insurrection may proceed. And I think that's also, a significant factor that the Supreme Court should have taken into consideration regarding the determination of absolute presidential immunity in the context of criminal cases as well. If Trump is not appealing this, then why would Trump feel that there's such an urgency to appeal in any other context? You would think that you would want to bring all of those arguments together. Absolute presidential immunity in civil, absolute presidential immunity when it comes to criminal cases. Although it's, I think, a bogus argument, a frivolous argument, a meritless argument for both. Why wouldn't you bring both? Petitions for certiorari right here. Let me just read from you from the opinion here, again, authored by Chief Judge Srinivasan, who says, since the Supreme Court's decision in Nixon v. Fitzgerald, presidents have carried out their official responsibilities free from any exposure to civil damages liability. Nixon, it's referring to the Nixon v. Fitzgerald case from '82, established a president's absolute immunity from civil damage claims predicated on his official acts. The object of a president's official act immunity is to assure he can fearlessly and impartially discharge the singularly weighty duties of his office. The president, though, does not spend every minute of every day exercising official responsibilities, and when he acts outside the functions of his office, he does not continue to enjoy immunity from damages liability just because he happens to be the president. Rather, as the Supreme Court made clear in Clinton v. Jones, a 1997 case, a president's official act immunity by nature does not extend to his unofficial actions. When he acts in an unofficial private capacity, he is subject to civil suits like any private citizen. This appeal calls for us to apply those key decisional precedents on presidential immunity to a decidedly unprecedented event involving the presidency, the riot at the Capitol on January 6, 2021, just as Congress convened to tabulate the Electoral College vote and declare the person elected president. The plaintiffs in the cases before us are Capitol police officers and members of Congress who were at the Capitol that day. They seek civil damages for the harms they allege they suffered arising from the riot. Although they sue various persons, the sole defendant named in all of the cases consolidated before us is Donald J. Trump. The plaintiffs contend that during Donald Trump's final months in office, he conspired with political allies and supporters to obtain a second term, despite his defeat in the 2020 election. He allegedly advanced that cause before January 6 by repeatedly making false claims that the election might be, and then had been stolen, filing meritless lawsuits challenging the election results and pressuring state and local officials to reverse the election outcomes in their jurisdictions. Those efforts allegedly culminated in the 75-minute speech that Donald Trump delivered at the rally on January 6th. According to the plaintiffs, Trump's actions, including ultimately his speech on January 6th, sparked the ensuing riot at the Capitol. Trump moved in the district court. It was actually before federal judge Amit Mehta. Trump moved in the district court to dismiss the claims against him, including on the grounds of official act immunity of presidents from damages liability. The district court largely rejected his claim of immunity, and Donald Trump now appeals. The sole issue before us is whether Donald Trump has demonstrated an entitlement to official act immunity for his actions leading up to and on January 6th, as alleged in the complaints. We answer no, at least at this stage of the proceedings. When a first-term president opts to seek a second term, his campaign to win re-election is not an official presidential act. The office of the presidency as an institution is agnostic about who will occupy it next, and campaigning to gain that office is not an official act of the office. So when a sitting president running for a second term attends a private fundraiser for his re-election effort, hires or fires campaign staff, cuts a political ad supporting his candidacy, or speaks at a campaign rally funded and organized by his re-election campaign committee, he is not carrying out the official duties of the presidency. He is acting as office seeker, not office holder, no less than are persons running against him when they take precisely the same actions in their competing campaigns to attain precisely the same office. Trump himself recognized that he engaged in his campaign to win re-election, including his post-election efforts to alter the declared results in his favor in his personal capacity as presidential candidate, not in his official capacity as sitting president. That is evident in his efforts to intervene in the Supreme Court's consideration of a post-election lawsuit challenging the administration of the election in various battleground states. He expressly filed his motion in the Supreme Court, quote, in his personal capacity as candidate for re-election to the office of the president, rather than in his official capacity as sitting president. goes on to say, and he grounded his claimed right to intervene in the case in his unique and substantial personal interest as a candidate for re-election to the office of president, rather than in any official interest in exercising the office's duties. In arguing that he is entitled to official act immunity in the cases before us, Trump does not dispute that he engaged in his alleged actions up to and on January 6th in his capacity as a candidate, but he thinks that does not matter. Rather, in his view, a president's speech on matters of public concern invariably an official function, and he was engaged in that. Is invariably an official function, and he was engaged in that function when he spoke at the January 6th rally and in the lead up that day. We cannot accept that rationale. While presidents are often exercising official responsibilities when they speak on matters of public concerns, that is not always the case. When a sitting president for re-election speaks in a campaign ad or in accepting his political party's nomination at the party's convention, he typically speaks on matters of public concern, yet he does so in an unofficial private capacity as office seeker, not an official capacity as office holder, and actions taken in an unofficial capacity cannot qualify for official act immunity. So Donald Trump did not appeal that order to the United States Supreme Court. He missed the February 15th deadline to appeal what I just read. Now, granted, later on, if there's a verdict that's reached, Donald Trump can go back, or on a summary judgment motion, Donald Trump later on can have the opportunity to file another appeal with the D.C. Circuit Court of Appeals and then file a petition for certiorari later. But Donald Trump did not file an appeal. Now, you may be saying, why didn't he? Well, number one could be incompetence. He is represented by Alina Habba, the worst lawyer likely in American history. So that is a possibility. And Alina Habba, when she was asked during oral arguments in a case before the Second Circuit Court of Appeals, she didn't even know what the Blassingame decision was. She was like, what's that case? I've never heard of that before. It's the case involving your client, Donald Trump. But I digress. But one of the reasons Donald Trump may not have appealed that to the D.C. to not have appealed the D.C. Circuit Court of Appeals ruling here to the United States Supreme Court is because, again, this is yet another ruling against Donald Trump, and it was so strongly worded, and by a judge who Trump appointed, Judge Katsas, who was one of the three judges who ruled against Trump. Perhaps Trump didn't want to bring this to the Supreme Court because he was worried that the Supreme Court would ultimately consolidate both, and Trump would lose on both rather than just losing on one, or that by bringing this to the Supreme Court, the fact that you had two, not the Supreme Court is going to just ignore that the D.C. Circuit made this ruling in Blassingame. Like, they're clearly aware of this decision, but perhaps Donald Trump just said, look, I just want to make my argument in the criminal case. I'm not focused on the civil case. If I show that I've lost twice to the Supreme Court, they're going to know that this whole absolute presidential immunity argument I'm making is doubly frivolous, right? Like, if I lost immunity in the civil context, then how am I going to argue even in the criminal context? Clearly, I should not be entitled to it in the criminal context if I wasn't entitled to it in the civil context of Blassingame. But nonetheless, Trump missed the deadline. The floodgates are open now. Anybody who wanted to sue Donald Trump within the statute of limitations period for conduct relating to the January 6th insurrection can do so. He did not file the petition for cert with the Supreme Court. Very interesting development indeed. Again, February 15th was the deadline that he missed. Tell me why you think he missed it in the comments below. Hit subscribe. We're on our way to 3 million subscribers. Thanks to your support, and have a great day.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the Midas Touch newsletter at MidasTouch.com/newsletter.